Hi, today's video will take you through what the current legislation enables you to do as a landlord to take back possession of your property, and it will also briefly touch upon some of the policies the Labour government are implementing and what this is likely to mean for you in the industry. So, the abolition of no-fault evictions. As you're aware, there has been some discussion for some time about the abolition of Section 21 notices or no-fault evictions in the residential housing sector. It was originally introduced by the Conservative Party, and the Renters Reform Bill was introduced to Parliament in May 2023. However, it was delayed in October 2023 pending reforms to the court system. The Labour government has committed to abolishing no-fault evictions, and the Renters' Rights Bill has had its first reading in the House of Commons on the 11th of September 2024. The key proposals are to abolish fixed-term assured tenancies and assured short-hold tenancies. Going forward, all tenancies will be periodic. Abolish the no-fault evictions under Section 21 of the Housing Act. Amendments to other grounds for possession to provide tenants with more security. For example, they will have a 12-month protected period at the start of the tenancy where they can't be evicted for the landlord to move in or sell the property. Many of the mandatory grounds will now have a 4-month notice requirement. And there are new protections for the tenants who are in arrears of rents. The mandatory threshold will increase from at least 2 months' rent to at least 3 months' rent, both at the time the notice is served and at the time of the hearing. The notice period for rent arrears will also increase from 2 weeks to 4 weeks. There are new grounds for possession, including whether the landlord, their spouse, partner or family members requires the property as their own or principal home. And tenants will also be able to end the tenants by giving 2 months' notice. Landlords cannot unreasonably refuse a tenant's request to have a pet at the property. However, landlords can require pet insurance to cover the cost of any damage to the property caused by that pet. They also have to provide a decent home standard where landlords can be prosecuted or receive a civil penalty for failing to address serious hazards. And there will be also the introduction of a new ombudsman to provide a cost-effective way for resolving disputes and a new database which aims to help landlords understand their obligations and provide information to tenants. Invariably, it is likely to be more difficult for landlords to obtain possession of their property going forward, as you will have to demonstrate to the court one of the grounds that applies. It's also likely to reduce the amount of control a landlord has over their property. Some of the proposals are concerning for investors particularly, as tenants will be able to serve notice to leave the property at an early stage. Therefore, if you are intending to take back possession of your property using Section 21, you may want to act now. It's likely that the bill will come into effect in spring 2025, but it's also worth noting that there are no transitionary provisions. Therefore, when the bill is passed, it will take effect immediately. So, what can you do now to obtain possession of your property? Under the current legislation, if a landlord wants to obtain possession of the property, they must serve a notice either under Section 21 or Section 8 of the Housing Act 1988. Currently, landlords can terminate an assured tenancy agreement under Section 21 of the Act for any reason. A proper notice must be served requiring them to vacate in 2 months, and if the tenant does not leave the property in accordance with the notice, then an application for an order for possession can be made to the local county court using either the accelerated or standard procedure. In some occasions, a hearing will not be required unless the tenant files a defence or a judge raises a concern about the tenancy documents. The accelerated procedure can be quicker for landlords, but it does not allow you to claim for any arrears of rent. And once an order for possession has been granted, a tenant will usually be given 14 days to vacate the property. If the tenant then fails to leave, the bailiffs can be instructed to forcibly remove the tenant from occupation. I'll shortly discuss the pitfalls for Section 21. The alternative to Section 21 is Section 8. Here, the landlord will have to serve a notice, but this will be based upon a ground contained within the Act. Some of those grounds are mandatory, including a ground for serious rent arrears and if that ground is met, possession must be ordered. Other grounds are discretionary, and the court must decide if the landlord has proven that ground and if it is reasonable to evict the tenant. So what makes a Section 21 notice invalid? A landlord cannot use the Section 21 procedure to regain possession of an assured short-hold tenancy, an AST, if they serve an invalid Section 21 notice. A notice might be defective if the notice was served incorrectly, the tenancy deposit rules were not followed, an EPC was not provided, a gas safety certificate was not provided, they failed to provide the how to rent guide to the tenant, or a prohibited payment was taken. A notice was served after a complaint was received about a property, and this is also known as a retaliatory eviction. Some of the list above can be corrected prior to service of the notice. However, I'll go on to two that pose the most problems. Firstly, deposit. If the deposit hasn't been protected properly in a deposit scheme, or the prescribed information has not been provided to the tenant within 30 days of receipt, then you have to return the deposit before a notice can be served. Secondly, gas safety certificate, and this is often the biggest downfall for landlords being able to serve a Section 21 notice. A gas safety check must have been carried out prior to the tenant coming into occupation, as well as a gas safety check being carried out before the service of the notice. If there is no gas safety certificate in place prior to the tenant taking up occupation, you won't be able to serve a valid notice. And if that was the case, the tenant was not served with the certificate, but there has been checks carried out. Case law shows that this can be rectified so long as the certificates are served prior to the notice of the Section 21 notice. So in summary, obtaining possession of the property is not always as straightforward as it should be, and so advice should always be sought. If you'd like to learn more, then please contact Myerson or the Property Litigation Department at our website or by telephone.